So we're going to be very conscientious about our time limits today, and that's about it. Mr. McBroom, you want to take it away? Oh, okay. We also have a new mic system, which I've already screwed up. My first opportunity to screw up, and I took it. Sorry about that.
Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for the regularly scheduled meeting of August 27, 2025. I'm Short-Term Rental Property Chief Bonnell McBroom III, and I'll be presenting the cases to the board for review in today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent as not to disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period of time for rebuttal. The board and their rules provide for cases without opposition, 5 minutes total for the appellant, including members of the public speaking in support of the appeal to present their case and supporting comments. For cases that have opposition, the rules provide the appellant, including members of the public speaking in support of the appeal, 10 minutes total for their presentation and rebuttal of the opposition's presentation. The appellant must reserve a portion of the allotted 10 minutes for their rebuttal. For members of the public speaking in opposition, 10 minutes is provided, and this is 10 minutes total for all speakers combined and not 10 minutes for each speaker. For members of the public that want to submit comments to be entered into the record prior to the meeting, that are either in support of or opposition to an appeal, the comments must be submitted to the board staff no later than 5 days prior to the public hearing. You can send those comments to strboard@nashville.gov. Documentation supporters or opponents wish to provide the board after the deadline can be presented to the board members by providing 8 copies at the public hearing. However, the board may elect to defer cases in order to review any materials received after the deadline. The Metro Code requires that these proceedings be taped. Therefore, it is imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted, if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The board will go through the cases set for public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on the cases before us today under the provisions as outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7-member board be present to constitute a quorum. The board rules require a majority vote in the affirmative of members present to grant an appellant's application. In the event that a majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive a majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. Any aggravated party may, within 60 days of the entry of an order stating a decision of the board resulting from an appeal hearing, appeal a finding of the board under common law writ certiorari in accordance with TCA 27-9-101 and following, to the Chancery Court within the same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that the permit must be obtained within 2 years for the board's approval to remain valid. I submit that all cases have been filed in proper order, all appellants have been notified as required by the code, and all affected property owners have been notified, and legal notification sign requirements have been met as required by the code. Chair Caputo, before we move on to the cases, we'll see if there's any elected officials present to speak. Seeing none, Our first case is 2025-017. Is the appellant present? Is there any opposition? Seeing none, there'll be 5 minutes.
Ms. Klein, you're welcome to come up if you like. You're welcome to wait until Metro has presented. It's up to you entirely.
Okay, this is STR case 2025-017, 2118 Elliott Avenue, number 2, owners Jeffrey and Linda Frey, Representative Tory Roos, and attorney Seth Klein. The STRP permit was revoked due to repeated violation of advertising excess sleeping rooms and excess occupancy. This is an RM20. This is residential multifamily zone district, which non-owner occupied permits were available until January 1st of 2022. This permit is governed by BL 2020-187 as the permit was issued on September the 10th of 2020. And in that in BL 2020-187, it states, all STRP, not owner-occupied activity, must be permitted in accordance with the Metropolitan Code 6.28.030. B, short-term rental property, STRP, not owner-occupied means a residential dwelling unit that is not owner-occupied containing not more than 4 sleeping rooms that is used and or advertised through an online marketplace for rent for transient occupancy by guest. And number 5, in regulations, maximum occupancy. The maximum number of occupants permitted on an STRP property at any one time shall not exceed more than twice the number of sleeping rooms plus 4. Simultaneous rental to more than one party under separate contract shall not be allowed. And the occupancy maximum shall be conspicuously posted at the STRP unit. Advertising an STRP for more occupants than allowed by this regulation shall be grounds for revocation of the permit. Every iteration of the STRP ordinance since BL 2015-94, effective date 1/25/2016, has contained the wording, the occupancy maximum shall be conspicuously posted within the STRP unit, and advertising an STRP for more occupants than allowed by this regulation shall be grounds for revocation of the permit. This property's permit was for 4 sleeping rooms. Twice the number of sleeping rooms plus 4 totals 12 occupants maximum. 6.28.030.B.5.L, number 3, denial and revocation. Before revoking any permit, the Department of Codes Administration shall give permit holder 15 days written notice of the alleged violation against him or her. Number 4, any denial or revocation of the STRP permit shall be appealed to the Short-Term Rental Appeals Board as an administrative appeal pursuant to Section 6.28.035.B of the Metropolitan Code. Number 5, once the STRP has been revoked, no new permit shall be issued to the applicant for the same property for a period of 1 year from the date of revocation. After the board has decided to grant, deny the appeal, or to modify the required waiting period when the appellant is able to apply for a permit pursuant to State of Tennessee Public Chapter 972, HB 1020, Section 1, 13-7-603A, the new permit shall be grandfathered, so the appellant shall be able to apply for a multifamily, not owner-occupied permit, STRP permit, even though these types of permits are no longer available in this zone district. The board has discretion under BL 2023-136. On August 24th of 2020, the appellants acquired the property at 2118 Elliott Avenue, number 2. The new owner's address recorded on the warranty deed is 2118 Elliott Avenue, number 2. This is important, and I make note of it because the notice of violation is sent to the address of record for the Metropolitan government, and this is the address for the record of the Metropolitan government, and it auto-populates as the address to send the notice. On August 26th pardon me, on August 26th of 2020, a multifamily not owner-occupied STRP permit application was submitted. On the 31st of August of 2020, Inspector Robert Osborne began to process the permit application, and additional documents were needed, requested, and provided. September the 10th of 2020, the permit was issued. On April 24th of 2021, we received a STRP hotline complaint concerning a truck parked on the sidewalk blocking access to the STRP. When the site visit was made, there was no truck parked at the location. On April 26, 2021, we received an email complaint for advertising excess sleeping rooms. Inspector John Phelps confirmed that the STRP was permitted to have 4 sleeping rooms, and it was advertised on Airbnb and VRBO as having 5 sleeping rooms. A notice of violation was sent. The advertisements were corrected within the remedial time, and the case was closed. September the 4th of 2021, we received a complaint on the hotline concerning a loud group at the STRP. However, the complaint did not mention amplified sound and was prior to 11 p.m., thus did not constitute a violation. September the 10th of 2021, the permit was renewed. The permit was subsequently renewed on September 10th of 2022 and 2023. On February 8th of 2024, we received an email complaint for advertising excess sleeping rooms. Inspector Phelps confirmed that the STRP was advertised on VRBO as having 5 sleeping rooms. On Airbnb, it was advertised for 5 sleeping rooms and 14 occupants. A notice of violation was sent. Again, the advertisements were corrected within the remedial time period, and the case was closed. September 10th, the permit was renewed, of 2024, the permit was renewed. We received an email complaint on December 5th of 2024 for advertising excess occupancy. Inspector Phelps confirmed that the STRP was advertised on Airbnb as allowing 14 occupants, and notice was sent. Again, the advertisements were corrected within the remedial time period. Case was closed. April 11th of 2025, we received another email complaint for advertising excess occupancy. Inspector Phelps confirmed that the STRP was advertised on VRBO as having 14 occupants. On Airbnb, it was advertised as having 5 sleeping rooms and 14 occupants. Inspector Phelps had requested the law department to issue a warrant. April 11th of 2025, we received a new direction from the Metro Law Department. Rather than request a warrant for repeat offenders of this violation, we should revoke the permit. Additionally, since the number of occupants is based on the number of bedrooms, repeat violations for advertising excess bedrooms was also a revocable offense. The owner is a repeat offender, even though the last violation was by a new property manager. The code holds the property owner responsible. On May the 2nd of 2025, the revocation letter was dated May 1st of 2025, was mailed to 2118 Elliott Avenue, number 2. By certified mail. As previously noted in this summary, this is the owner's address of record based on the warranty deed. It was marked returned to sender, vacant, unable to forward by the Postal Service on May 7th. It was received back at our office marked May 9th of 2025. May 19th, 2025, a second letter dated May 19th with an extended expiration date was sent by certified mail on May 20th of 2025 to the same address. This letter was also returned, marked returned to sender, vacant, unable to forward by the Postal Service on May 25th, 2025. June 3rd, 2025, the 16th day after the second letter was dated, Inspector Phelps reviewed the ad and found that it was still posted and active. He went to the property and posted the revocation letter and the stop work order and documented that with photos. On June 10th of 2025, Ms. Bray and the new property manager, Ms. Roos, came to our offices. I met with them and explained the situation, and at that point, I must take issue with statements in the petition submitted by counsel for the appellant, Mr. Klein, who was not present at the meeting, concerning evidence that the revocation letters were mailed. Inspector Phelps was present and can attest to the evidence that was presented during that meeting. Ms. Ray requested copies of the evidence, and I explained that we would produce a copy of the entire case file for the appellant if she filed a public information request. And that request was filed with our office. On Thursday, August 21st, 2025, I received word that a public information request had been made on August 12th, 2025 by the Office of the Attorney for the appellant in this case. The request was routed to Metro ITS Department. Our office was not copied on the request. The request was filled on August the 18th. This case summary was completed on August 15th and emailed to the board and staff on August 16th. After I became aware that the request was made, I sent this entire case summary to the Code's Assistant Director for Public Affairs to forward to the appellant's attorney, Seth Klein, on Friday, August 22nd, 25. The update was sent to the STR board and staff. Mr. Klein contends that the revocation is tied to the 3 violations in section 6.28.030.B.5.L. Decline or revocation of the permit. Number 2, if the zoning administrator determines based on reasonably reliable information that the zoning administrator has obtained, including without a limitation, public records or reports, records of regularly conducted activity or direct or online statement against a person's own interest that as a direct result of the operation of the short-term rental unit, the permit to operate the STRP may be revoked if no appeal rights remain. However, this revocation is based on a separate section of the code that was noted at the beginning of the case summary, 6.28.030B5. Maximum occupancy, the maximum number of occupants on an STRP property at any one time shall not exceed more than twice the number of sleeping rooms plus 4. Simultaneous rental and more than one party under separate contract shall not be allowed. The occupancy shall be conspicuously posted at the STRP unit. Advertising an STRP for more occupants than allowed by this regulation shall be grounds for revocation of the permit. Pursuant to the State of Tennessee Public Chapter 972, HB 1020, Section 1, 13-7-603B, the ordinance, resolution, regulation, rule, or other requirement in effect at the time the property began being used as a short-term rental unit is the law that governs the use of the property as a short-term rental unit. Furthermore, the State of Tennessee Public Chapter 972, HB 1020 does not mention 365 days, thus that time period is not applicable to this revocation. We believe that the zoning administrator did not err in the revocation of this permit. The last several pages of the case summary are screenshots of website advertisements for the property captured over time by Metro's compliance contractor, Gronicus Host Compliance. It establishes a pattern of advertisements being out of compliance on occasions other than the times our department was aware of the violations and for which the property was cited.
Board members, Joey Hargis, Metro Zoning Administrator. Mac did a good job of thoroughly summarizing the issues. I just want to cover one thing in particular, and I guess this is sort of a case of first impression for this board in that most of the revocations that come before you are either something where they operated without a permit or they don't live where they say they do. As Mac talked about, up until April of this year, we did not bring these cases to you guys. We took them directly to environmental court. So this one being a case of first impression of some resort, and as Mr. Klein and I've talked both off camera, but I'll say it here publicly, that the issue that I revoked was not on 3 violations of a generally applicable rule. It's the fact that he violated the ordinance on its face. You're not allowed to advertise more than 4 guest rooms. So that, to me, is grounds for revocation. As you noted in the summary, this is not a one-time thing. You know, this has happened multiple times. I advise Mr. Klein's clients to put a Post-it note or something. Whoever's doing the property stuff, you know, put a Post-it on this one that it's 4 and only 4. But with that, I did revoke. As regards to whether the applicant received notice, we do operate under the mailbox rule. You know, we send it certified to where their tax bill goes. So also another suggestion that you update your mailing with the tax assessor's office, because your tax bills are probably bouncing as well. But those are 2 issues. I will tell you, members, this particular case, I don't object if this board feels compelled to reduce the time for refiling, given that this is the first type of case that this board has heard. And given that it seems like when we have brought this up to this operator's attention, they've been quick to correct the situation that's come up. This is not really a hill that I feel strongly about as I do with someone's residency when we're dealing with owner-occupied. That is one I'm 100% serious about that you can only have one principal residence. But since we're dealing with a non-owner occupied, the good news is we don't have to worry about any of that stuff today in front of us. But again, I'm happy, however you guys rule. You know, I think initially, and the council member may talk about this, may be able to speak on as well, is the key part for the council is we just don't have too many people in these homes. It wasn't so much the number of bedrooms. You know, if every guest had their own bedroom, is that necessarily such a bad thing? No, we just don't want too many people. So, but it is, as the code's written, is a violation to advertise more than 4. So if you all see fit to reduce the weight, I have no objections to that. So with that, that's all I've got to say, and turn it over to you, sir. Chairman.
Great, thank you. Before we hear from the appellant or his attorney, could we see if there are any questions for Metro? Go ahead.
Great, thank you. Do we know what the address was listed on the application? Because I guess I'm surprised to hear that we send notices to the address on their warranty deed versus what they list on their application as their mailing address. It might be the same in this case.
No, actually, that is not something that we control. That is based upon what is on the warranty deed. The information is supplied. And when we write a notice of violation or a revocation or cancellation letter, that address auto-populates. We have no control over that. That's the official address of record with Metro. So that's where the notices or the letters will be sent.
Okay, that's helpful. Do we inform applicants of that at the time that they apply? Because personally, like if I were applying for something and I put a mailing address on the application, I would expect that to be used as my mailing address for notification of things.
Sorry, I closed it.
Actually, the address of record is again based on the warranty deed. Now, we don't necessarily review the warranty deed at the time of the application.
Right, I hear what you're saying. I'm asking if applicants are informed when they do their application and they have to put their address on the application, are they informed that if there are any notices sent out by mail, they'll be sent to the address on your warranty deed for tax records?
No, because we may have no way of knowing that. As I say, we don't generally review the warranty deed as a part of the application process, so we're not keyed into that.
Right, and I'm not, I
I think more
understand
to
that.
Ms. Williams' point, all of the notices in both the zoning code, as far as public hearing notices for rezonings,
Right.
Public hearing notices for this meeting are all sent to the owner of record, so it goes to that. But your point's well taken. If they provide us something different, we'll make sure going forward that that one also gets.
Yeah, because,
some kind of
and I'm not,
notification.
like, suggesting that y'all need to be cross-checking, just like something on the application or something to the applicant saying, hey, just so you know, if you, because I don't even know what's on my warranty deed. So I don't know.
Well, certainly in the non-owner occupied space, that's important. In the owner occupied space, if you're providing me an address of someplace other than, then we have an additional problem. So,
Yeah.
No problem. That's points well taken. We'll work on our procedures then.
Thank you so much.
Great,
Thank you, Chair.
sure thing. Okay, so Mr. Klein, if you would work on this microphone thing with me, if you would press, I'm assuming that you'll be speaking. Okay, and is this Mr. and Mrs. Fry? If you folks are going to be speaking, you have to understand that there's 5 minutes shared between the 3 of you. Okay? So I'm gonna, if you would please select your mic, I'll open it for you. I'm not seeing anything on here. It seems to be on. So are those always on? Okay, so we don't need to recognize Okay.
Correct.
Fantastic.
Mr.
Okay.
Chairman, if I could, just correct one thing.
Yes.
Our notice comes from the assessor's office, not from the warranty deed. It does, I know that's a distinction without a difference to lay people, but that is very different. It does come to the assessor's office is where that information is grabbed from. So I just want to get that corrected for the record. And yes, this mic and those mics are actually independent of each other.
Okay, super. All right. With an eye on the clock, let's hear from Mr. Klein about this case and the situation the Fries find themselves in.
Thank you, Ms. Run. Seth Klein, Collins Legal, mailing address 1015 Fatherland Street, Unit 205, Nashville, Tennessee 37206. A few points of clarification from the onset. After speaking with Mr. Vravid and after now having reviewed the packet I received late Friday afternoon, I do not dispute the revocation of the permit and the color of the law for which it was revoked thereunder. As Mr. Hargis said, we spoke off camera, which he reiterated on camera, that we spoke about that again. No dispute there. As with regard to the conversation that Ms. Fry and Metro Codes had that I was not a part of, I've since received additional clarification from my client. And again, that is not a point of clarification. Mr. McBroom, I would not assert or otherwise state that and having know what I know now. So I want to expressly state that for the record here as well. And again, with regard to the mailbox rule, have no issues with that. I do believe, Ms. Williams, that a correction in the notice process would be great. It would limit the work. It would limit how often I would probably get to see y'all, more likely than not. But that it is something I think that while I understand the process, for specific situations like this, that would likely have resolved this. Lastly, and then with regard to the instant case, there's no dispute that there have been errors with regard to the advertising of this property. There have been some changes in property management. My client is very much aware that she is responsible for the actions of her agent. With that, I have explained to them that there is no error by the zoning examiner or administrator in this case. However, we can petition this board for relief from the 1 year, not 6 month injunction, as I stated based on the different law, it would be 1 year from that injunction. There's not a tremendous amount to add. Mr. McBroom did a tremendous job going through the record, but just some key points that, are to highlight with regard, to the Fries is that, and it's listed in addition to the letters of support that are included in both the original petition and the supplement that was filed pursuant to advice of Mr. Bond from the last appeal hearing that I was at. And our position is this, and I know I'm short on time. Appellate acknowledges that as the holder of multiple short-term rental permits, she is well aware of the rules and regulations for operation and advertisement. We understand that there have been violations of that and that a mistake or confusion of the law is no excuse. The appellant further acknowledges that its agents and assigns, i.e. their property managers, are responsible for that. But as stated by Mr. McBroom and Mr. Hargis, any time that notice has been received in the past for a situation like this, it was corrected and abated in a timely manner. Now, I do know that there were instances of additional advertising that were not listed as issues that were caught or otherwise cited. But again, in an attempt to show that Ms. Fry, does understand these are her mistakes. She's made multiple mistakes. She should know this by now. I have the same question as to why this keeps happening. She's assured me she has a process in place to make sure that does not happen again. The reasons why do not matter. It's a violation. But Ms. Fry is very active in the HOA Association for the complex. She has letters of support, as I said, in Collective Exhibit 3 to the initial petition, and then additional letters of support and the supplemental appeal. And so with that, again, acknowledging there is no error. This was user error on my client's part. And with it, we have not advertised or operated since on or around June 5th. And we are requesting relief from the one-year injunction period. And with that, I will yield the rest of my time.
Great, thank you. Does anyone have questions for the appellant before we get started?
Surprise, I have questions. Okay, so I appreciate the acknowledgement that errors have been made. I know, Mr. Klein, you said, like, it doesn't matter why there have been violations, but I am interested as to why this keeps happening, because it's like repeated over a series of years, and that's a little concerning for me.
My name is Linda Fry. Thank you all for, can you hear me okay?
And your address, please.
3112 Windsor Road, number 230, Austin, Texas, 78703, that's been on record with Metro since 2020. Good question, Ms. Williams. I appreciate you all's time and taking this time. I take full responsibility from past errors, and this is why sorry, I'm getting emotional. We hired a property manager. She made mistakes we weren't aware of. We didn't know our permit was at risk. We didn't get any notifications through Metro. They were not mailed to our address on file since 2020 for 3112 Windsor Road, number 20. Had we known, we understand the burden falls on us. We take full responsibility. Had we known there was any sort of error, it would have been corrected immediately, but we didn't get that chance.
But you were aware and
Correct.
had received notice in the past?
Yes, and this is why we decided to hire a local property manager. We live in Texas. We need to get someone else who can do a better job than us.
Okay, and then the local property manager made the same mistake again?
She sure did.
That's unfortunate.
Yes.
So Mr. Klein noted that you now have a process in place to ensure that this doesn't happen again. Can you tell me a little bit more about what your plans are moving forward?
Do you want me to answer?
Whoever has the answer to that
Yes,
question is
we
fine.
were going to do additional training for our manager, make sure she's aware of Metro Code, have her take on classes, maybe talk to Mr. Phelps and say we need to make sure she's better versed on exactly what the rules and regulations are. So going forward, we stay in complete compliance. I'm on the HOA board. We have another short-term rental. My priority with other rentals have been parties out of control. And I was the one who hired a security management company to make sure our property was safe. So I'm all about safety. And it's unfortunate, this was an unintentional error by her part, and we are going to make sure it never happens again, and it's corrected by additional training.
Okay, thank you.
Thank you.
Any other questions? I kind of want to follow up on Nicole's question. So in 2021, you got a notice of violation and you made a correction. In 2024, you got a notice of violation, you made a correction. In December of 2024, you got a notice of violation, you made a correction. So I'm a little surprised that this wasn't something that you spoke to your new person about with great emphasis as this is kind of a bad track record. And you would think this would be something like, my goodness gracious, we cannot do this again because we've already gotten 3 letters of violation, right?
Well, this is exactly why we thought her being local and knowing all the rules and regulations, this is why we went with someone local. Unfortunately, she was not as aware and made the same unintentional mistakes. It was a photograph. So when you add a photograph, it immediately changes the listing completely. So she was unaware of that, and it was unintentional on her part.
And my understanding is you own other Airbnbs?
One more.
One more here in Nashville?
Yes,
Do you own
ma'am.
any in Austin?
No.
Okay. I think your husband was trying to interject.
Jeff Fry, the same address on Windsor.
Please, just for the record, if you'd be so kind.
Yeah, 3112 Windsor, number 320.
Austin,
All right.
Texas.
Austin, Texas, yes. Okay. I was just going to reiterate, had we known, we would have corrected it immediately. There was a 3-year period between 21 and 24 where we heard nothing, we received nothing. We have received stuff in Austin regarding this property. We just assumed that any violation would come to Austin. We don't even get mail at Elliott, not that I know of, not that I've ever seen. We come into town, and stay at this very property maybe 4, 5, or 6 times per year. And whenever we do that, we try to do our best, and this is what my wife was saying. This is why we hired a property manager. We're trying to do this from another state. Didn't work out so well. It's not like we were creating content each time. As my wife knows more than I do, once a new photograph gets put in, the websites for Airbnb or VRBO or whatever just kind of take it from there, and stuff can slip through the cracks. And it did with us in 2024. And then when the property manager got involved, it did again. So we're not going to let that happen. We know all the rules now. We're not going to let that happen. Thank you.
I'm also looking at the email from your new property manager in which she identified this as a very minor mistake. And yet it's the same thing over and over again. It's, who's seat 11? Somebody wants to speak.
Actually, I've changed my mind. I'm good.
All right. Anyone else? Any questions? Okay. Nope. Good. Okay, we're going to close the public hearing. We're going to discuss this amongst ourselves. Unless we need further information from you, we will not be communicating. And so even if you hear things you object to being spoken about, please don't interject because the public hearing's closed. All right?
Thank you.
Thank you. You're very mature for 12.
Hello.
Yeah.
Great, thank you. So just a little bit, just some thoughts on, as Mr. Hargis said, about my perceived intent of why this section of code regarding the occupancy limits for short-term rentals has been on the books since before I served, so I did not follow that debate as closely. But, I mean, generally, occupancy limits are in place for kind of quality of life reasons for like surrounding folks as well as the people inhabiting a place, and life safety. So, fire, I would assume when that debate was happening and fire got the inspection process and the fire mitigation requirements, that they, there was some level that they would have certainly not been comfortable with. And so I imagine that they were part of that conversation with the occupancy limits. We actually have much stricter occupancy limits for Nashvillians. So I think it's up to 5 unrelated people in a dwelling unit, which is, well under half of what we allow for short-term rentals. So that's a pretty generous delta there for the transient visitors versus the Nashvillians. But nevertheless, I do, my concern with this one is just the kind of repeated nature.
Yep.
And, I understand how maybe someone who's not familiar with the code and the regulations could say this is a minor thing, but, as someone who's circling back to kind of the quality of life side of why some of these regulations exist, if you're advertising for 15 people and there's a family reunion and it's regional and nobody's flying in, everybody's driving in, there's not many neighborhoods in Nashville that you can just say, we're going to put 15 cars right here and it not be a headache for neighbors. So, and again, the limit that's in there is so generous that I have a hard time with exceeding it repeatedly and being notified and not kind of locking that down as part of your business.
Yeah.
So that's where I'm at.
Yep.
Same. It's, it becomes tantamount to sort of throwing the issue over the fence, sort of acknowledging that there was a problem, acting to resolve it, and then not bothering to sort of conduct enough diligence to make sure that the same problem, there's an automatic process by which the website updates bedrooms. The first thing I would be doing is checking to make sure that didn't happen. Again, and also it would be a pretty much entry-level job requirement for the person I hire to manage my properties to know the code inside and out, as to these things. And this is one of the violations where the immediate remedy is revocation. So I would think that this would be one that you would take extremely seriously the first time it happens. So I'm not inclined to suggest any relief, given that we're talking about a period of years. and not just sort of a couple of instances within the same year and then it never happened again. And there have also been remedial measures taken which failed.
Yes, so I agree with everything that my fellow board members have said. I also want to point out that repeated violations, like those violations require staff time, staff resources, city resources to address. It's not by magic that these notices go out, like staff have to review what's on the books. And so I think for me, it's also particularly frustrating because it simply cannot be in the interest of public policy that people continue to violate, and then as long as they abate within 15 days, then they just get to continue to violate and continue to violate. Like that is, I would say that's sort of, it's not a non-issue because it requires resources on the city's part. I would say that speaking to Councilman Parker's discussion of sort of the purpose of these limits, I do find it somewhat compelling that we have testimony in the record from neighbors saying that nothing has happened that has really been a huge issue for quality of life. So I certainly think that some time is warranted as they've continued to violate and continue to violate. But I do think that given the testimony from neighbors saying like they are model STRP owners, aside from this, obviously, I could see some reduction, but certainly not any type of generous reduction.
Right. Yeah, because I mean, obviously, whether it's fair to do so or not, what we will do here today, since this is the first time we're deciding this issue, will have precedential effect or meaning to the people that come after this. And when you talk about granting relief to, granting relief to permittees that have had years of documented violations, that paints us into a particular corner.
Yeah.
Regarding how
Could
we
I,
handle.
just for, if we're contemplating potentially considering any sort of reduction, could I ask Metro, because it's been stated both 6 and 12 months, just for board members' clarity, for the public's clarity, for everybody's clarity, could Metro let us know what penalty, what waiting period is kind of imposed by default here? Is it 6 months or 12 months?
Before you answer, I'm afraid we need to open the public hearing in order to do that, in order to get more comment from Metro. Isn't that what
Hear
we
from
decided,
staff.
Ann?
Is it-
And if it is, can we talk to Ann without opening the public hearing?
Yes, Charlie, you can talk to people about it.
Okay.
It's got to be red. Green is a request to speak, red is,
Okay, wait. So are you, so you're 13?
we're all learning the new system, folks.
Still waiting.
Oh my
Perhaps there
goodness,
should have
I'm
been pre-meeting
sorry.
training for this.
Okay.
have
to
Yeah, I think
scroll,
to
I'm
speak to
sorry.
legal, you wouldn't have to open public hearing, but I think to speak to Metro, I think.
Okay. And do you happen to know, Ann, before I reopen the public hearing, do you happen to know if it's 6 months or 12 that?
It is 12 months.
Governors, okay,
Yes, under the
that
Pocono
governs,
ordinance,
thank
yeah.
you. Look at that, we didn't have to open the public hearing. Okay, while I have the mic open, and who is seat 9?
That's rumbling.
I'm going to open your mic just so it's on. But while I have my own open, I think quality of life is a huge issue, and I do agree with you, Nicole, like, aren't we lucky that there were a handful of neighbors that sent letters saying, hey, they haven't been in any trouble. There was a call about a big party. And I know that we've heard from so many neighbors in the past, this was the intention of the ordinance, maintaining as small a group as we could get past, right? Despite the fact that, kids at Vanderbilt are not permitted to live in situations like this. The fraternities over at Vandy can only have 5 people living together. It is very generous, and the quality of life issue cannot be understated. You look at all these ads, huge groups, perfect for huge groups. That's what every neighbor fears.
Yeah.
So the bigger the group, the bigger the risk of a problem, and I think it's not to be understated. Ramon first, because he's been so patiently
sorry.
waiting. I opened everyone's mic because I just don't want to keep screwing up.
Yeah, so I guess I just wanted to weigh in and say, one, I agree with everyone. The repeated violations bother me. Initially, I was not inclined to give relief. Where I struggle is I do feel that we've been very generous in granting relief in some instances in the past for much more egregious things. And I'd just like us to start being a little more consistent. If we're not going to grant relief in this situation, let's take a harder look at some of the cases that follow and be consistent, because I'm struggling with this one a little because our appellants are here. I do think there's some effort being made to mitigate the circumstances going forward. Yeah, I want us to be consistent. And a part of the reason we exist is to hear these cases and consider granting relief, so.
Yeah, no, I agree, which is, I'm typically the first person to say we should grant some relief. So I do want to be careful, though, about taking into account, like, things that we've heard from neighbors in other cases, like,
I'm really just speaking to what the spirit of the ordinance
Right.
was. The
Okay.
spirit of the ordinance was to protect the
Yeah.
lives of Nashvillians
Correct, yes, and
in a tiny little way, because it's
Yes.
still 14 people.
for sure. And so I think given this case, taking this
12
case
people.
as it is presented to us, the testimony that we have from neighbors in this neighborhood, from a representative of the HOA in this neighborhood, and, HOAs are not quick to, I would say HOAs tend to come down pretty hard on people. So
Yeah.
like, if you've got your HOA representative from this neighborhood saying, this has not been a problem for us, that, to me, when we're thinking about the purpose, would granting relief go against that purpose? And that's one of the things that we consider is like the public policy effect of granting relief. Again, I don't think we should say tomorrow you can go and apply, but I do think 1 year is a lot in this particular case, given the facts that we have here. And everyone within a certain radius would have gotten a notice. So if people wanted to write in opposition, they could have, certainly.
That is true, but
Yeah.
there was at least somebody making all these complaints. These were
Right.
not pulled from host compliance. These came as an email complaint, an STRP hotline complaint. These were, now, it might have been one person, granted. Nonetheless, this is coming probably from a neighbor who's
Yeah.
impacted. So, I mean, we have to see that
Certainly,
they're,
yeah. I just think weighing,
okay.
yeah.
We're,
We have numbers in mind.
do we have numbers in mind? Let's start haggling.
So they've already been out of operation for
Since June.
almost 3 months, right? July, August, September. They said on or around June 5th.
Right.
I'm leaning towards 9 months.
Total.
9 months from when?
From June 5th, was it? Was that the date that,
That's the date that they stopped operating.
or 9 months from the date of the,
The revocation.
yes.
It was still posted on June 3rd, and a stop work order went in. So June 3rd, June 6th, somewhere in there. 9 months from June 6th is your vote?
Yes.
I mean, that feels, to me, excessive, but I don't think I have the votes for anything else. So, I mean, we could just take a vote and see what
Yeah.
happens.
Do you
I'm
want
also
to make a
meeting
motion?
halfway. I think they asked for 6 months.
They asked for
Relief from
their
6 months.
immediate relief.
Yeah.
Well,
Yeah.
Would you like to make a motion for 9 months?
Yeah.
Knock yourself out.
Move that the zoning administrator did not err and move to grant relief and the appellant can reapply in 9 months for a permit.
9 months from June 6th.
9 months from June 6th.
Second.
Okay.
Can I see a show of hands? Ah, no. That did not pass. Can I see anyone abstaining? Well, you're abstaining.
Well, you can't vote.
Okay, so, interesting. Would we, that motion failed.
Yep.
Would we like to entertain another discussion or another motion?
Let's see here. I'm sitting here playing with dates in my mind. What date was the revocation effective again?
We were told June 6th. June 3rd, there was a stop work order,
Okay.
but there doesn't seem to be, we're comfortable, June 3rd was a stop work order. During,
Okay, so they
during
complied.
direct testimony, they
Okay,
told us it
okay.
was June, they stopped as of June 6th.
Okay.
When you think about, it now, 9 months, but we've already shaved off the
Right.
2 months, 2.5
That's-
months they've waited to be
Right,
here.
that's
So
what-
it's,
that's what I'm
it's in
thinking
essence, what is it, 6 months, more or less from today?
Right, and that's.
Which I think is
That's where I'm getting hung up a bit.
Pretty,
I think that's very generous.
I agree.
Yeah, I
So
think
do you
that's
want, so you felt that the motion was too generous?
A tad, yeah.
Well, how are we going to split this baby? Because I think Nicole thinks it's too punitive.
Yeah.
Oh, goodness, okay.
I think we have a better chance of convincing Nicole.
No, that's not true.
I don't think so.
No, that's.
Well, then
that's
can
not
we
true.
convince you? Because then we can pass the motion.
Well, you have a 0 chance of convincing me, so maybe you do have a better chance with Mr.
Well,
Bond.
I certainly don't think it's nothing that's worth another 30 minutes of discussion. So let's try the motion again.
I'm going to make a motion
Well,
that we,
see what
sorry,
happens.
go ahead.
The motion failed, so unless someone makes a motion to reconsider, but there was no prevailing.
Oh, I was just going to make a new
side.
one.
Oh, a different time period?
No,
No,
Well, I think you can't make the same motion unless someone,
Thank you. If you've had enough discussion that would warrant a new motion, you can
revive it.
consider the same motion again.
yeah.
consider the same motion or make the same motion again.
You would have to make it again.
Okay.
And then consider it, but there'd
Let's
have to
go.
be, enough discussion to feel like
Okay.
it's a new motion almost.
I'm not that original, so I'm just going to make the
Okay.
motion again. So I move that the zoning administrator did not err, but we will offer relief of 9 months starting on June 6th. Do I hear a second?
Second.
Can I see a show of hands? The motion passes. So 9 months, there is a relief of 3 months, but the date starts on June 6th, so someone who's better at math than me can
March,
figure that out.
That'll be March of,
Okay.
March of
And you can work
2026.
with staff on that. Thank you so much for your time, folks. I'm sorry about all the mic confusion, you guys, sorry.
You're learning on the fly.
Oof,
You're learning on-
baptism by fire. Okay. Great. Our next case. I'm going to butcher Ms. Glory's last name here. Come on up. And you can, when the time comes, you can instruct me properly on how to pronounce it. Have a seat, but just relax because we're going to hear from Metro first.
This is case 2025-018, 3660 Donna K. Drive. Owner Abraham Amunzi and appellant Glory Amunzi. The permit application was denied. The property operated as a short-term rental property before obtaining a permit. This is an R10 zone, and only owner-occupied permits are available. This is governed by BL 2024-478, Section 6.28.030.A.5.L.7 of the Metropolitan Code. The penalty for operating a short-term rental without a permit shall be, number 2, upon determination of the zoning administrator or the zoning administrator's designee that the short-term rental property operated without having obtained a permit, there shall be a waiting period of 1 year from the date of such determination by the zoning administrator or designee for the property to become eligible for a short-term rental permit. The board has discretion under BL 2023-136. On June 30th of 1999, Mr. Ermonte acquired the property at 3660 Donna K. Drive, Nashville. On March the 5th of 2025, Metro's compliance contractor, Gronica's Host Compliance Tracking, shows an Airbnb advertisement was posted. June the 18th of 2025, the address for the property appeared on the monthly list for June provided by Gronica's Host Compliance for properties operating without a STRP permit. Inspector John Feltz verified that the advertisement was posted with documented stays. Inspector Feltz sent a notice of violation for advertising and operating without a STR without a permit. On June the 23rd of 2025, on or about this date, Inspector Feltz received a call from the appellant, and Inspector Feltz explained that the STRP ordinance requires a 1-year waiting period from the date of the notice of violation, June 18th, 2025, before the STRP permit application can be submitted due to advertising and operating a STRP without a permit. The appeal was filed. Between March 2025 and August 6 of 2025, there have been 20 documented stays. The appellant, Ms. Gloria Unmonte, and Ms. Unmonte is not on the deed for the property. I have been unable to establish a relationship, but I believe the appellant to be the daughter or niece of the property owner, Mr. Abraham Unmonte. According to our records, this is no longer the owner's primary residence. There are no complaints on the Hub Nashville or the STRP hotline, and there is one letter in opposition to granting the appeal.
All right. Does anyone have any questions for Metro before we hear from the appellant? Please. Go again, sorry. There.
Does it matter that the appellant, that we haven't established the relationship between the appellant and the homeowner?
It matters as to whom would be able to make application for the permit, but that is really not what you're considering today, just whether operation occurred prior to, so that they're not eligible to apply for a permit for a 1-year period. And unless you choose to reduce that period under 136, in the event that you do so, then they would have to work out with staff whether they're eligible for it being primary residence of the owner.
Okay. Thanks.
Okay.
Thank you. So Metro didn't catch this until June, right? Like that was, but it had been operating since March, but the first notice that we sent out was in June.
We receive a monthly list from
Right.
Host Compliance.
Right.
And we're dependent on them for that list. So when they have to identify an advertisement, and that involves pinning it to an address, at which point they start tracking the activity that's related to it in terms of rentals. But as soon as they make the identification and they see that they're advertising and operating, they have access to our records to determine their permit status. And if they do not have a permit, then they appear on our monthly list, and that was the earliest available list for which it was available after being identified.
Right.
Therefore, we, at that point, verified the violation and sent the notice.
And to be clear, I'm not suggesting Metro did anything wrong or there was any like lack of due diligence. I'm just trying to establish a timeline of when the appellant was informed, and that was in June, right?
Yes.
Okay. And then do we know if there were any documented stays after the time that the notice of violation was sent?
Yes, there were.
Do we know how many, roughly?
Well, the total number of advertisements was 20, but I would have to pull up, and you should have in your packet the summary of documented stays. I can total that quickly for you, though. It would be under the matched property listing. Let's see, we have
Oh, okay.
1 for July, 5 for June.
Okay, thank you. I see it now.
Well, also, this was printed sometime back, so if you look at the end of just before that matched property listing, you'll have a listing of all of the documented stays that occurred, and if you pick up with the June and go from there, then you can total what's happened in the interim between receiving the notice and now.
And do we know if this is still posted and active?
It was yesterday,
Okay.
but
thank you.
the calendar is at 30 nights.
Oh, okay. Do we know, so yesterday when you checked, it was 30 nights, so not short-term?
Well, the stays reflect that they were short-term.
I'm
but
just asking right now.
As it stands now, it is not supposed to be able to be booked for less than 30 nights.
And it is not able to be booked for less than 30 nights currently?
Well, we don't go as far as to provide a credit card, but the step before that, it says 30-night minimum.
Okay, great.
You select dates, it says 30-night minimum.
Perfect. That's what I wanted to know. Thank you so much.
Great. Any other questions before we hear from the appellant? No? Okay. Ma'am, your mic should operate quite easily with just push of the button. Fantastic. If you could start off by giving us your name and your address where you live, and tell us about your situation. And I don't believe we have any opposition to this case. Folks, neither of you are here in opposition to this case, right? No. Then you'll have 5 minutes to tell us about your situation, okay?
Yeah. My name is Gloria Runse. I'm a sister-in-law to the owner of the house. His younger brother is my husband.
Okay.
My address is 366 Donake Drive, Nashville, Tennessee, 37211.
And tell us about your situation
Yeah,
here.
so before I started Airbnb, I called Airbnb that I want to start doing Airbnb. So they said I should set up an account, make sure I have a fire extinguisher, a smoke detective, and a lot of stuff. So I already had some, so I bought some like extra pillow, blankets, and we also did some a renovation to the house. So after that, I called them back, so I set up an account, so I started doing it. I didn't know I was supposed to get a code, permit code before I started. So although before I started, I told my neighbors that I'm going to start doing Airbnb, they were like, oh, okay, Glory, because I have a very nice neighbors. We live like family. So after that, I think two months, 3 months later, I got a letter saying that I was supposed to get a permit code, that I should take it out from the ad or change it to 30 days. So I called, so I told the guy, I think David also picked the call. We explained, I said I didn't know. If I had known, I would have done everything before I started doing it. So he said I should appeal, because they said I should wait a period of 1 year before I can start again. So I'm appealing the case right now, that you guys, Your Honor, and the members of the board, you should please reconsider my case so I can go back to short-term rental. Because if you check my review, you can even see a lot of comments, like I have like 5-star, they love the house. It's a very quiet neighborhood, and my house, there's a lot of rules, like they are be abided to the rules. So I haven't had any issue since I started doing it, but right now it's on 30 days, because they said 30 days, that doesn't need any code for it. So I'm here appealing the case so that you all can reconsider so I can go back to short-term rental.
Okay. Anyone have any questions? No? Okay. Thank you so much for your time today. We're going to discuss this amongst ourselves. You can return to your seat if you like. Unless we have questions for you, the public hearing is going to be closed. So you can hear our discussion, but you're not going to be able to participate, okay?
One more thing. Can I
Sure.
say? Yeah, they also asked me to send letters to almost 280 letters to neighbors. Even some of them that is not even in mine, like some of them in Brentwood, in Georgia, the address they sent through my email. So we sent everything. Then I also have a signboard in front of my yard right now, saying that if anybody objects or, they should come. So I did everything they want me to do. I
Yes.
follow everything. If you can please reconsider me.
Well, you wouldn't be here today if you hadn't followed all those steps. So yeah, we assumed that you'd done all that because that's a requirement in order for you to be at the hearing today.
Okay, thank
Okay?
you, ma'am.
So thank you. We're going to discuss this amongst ourselves and we'll get back to you.
All right.
All right, thank you.
Thank you.
Do it, you'll have to do it again. Because I keep hitting all off instead of mic on. All right, if anybody else wants to get themselves aligned exactly, I've just opened everyone's mics because I'm guarding and hedging against my incompetence. Okay,
So, wow, all the mics give us kind of a hall effect, like a reverb. That's cool. So this is one where, I mean, it seems like we've had cases like this before where somebody,
this might be a little too close to you.
to me, okay. We've had cases in the past where, it does seem like an honest mistake. I mean, I don't think this is like a, apply tomorrow, but I do think that whatever wait period is enacted, I would encourage the appellant to research the requirements for a permit in this zone, which is, owner occupied, check if there's an HOA, things like that, because when you go through the permitting process, those things are likely going to come up. But as for the request today, I mean, this seems like I screwed up and asking for relief, so I would be inclined to grant some degree of relief, but that's my thoughts.
Okay. Who else?
Turn my mic off, but I agree with Sean.
Okay.
Yeah, same. No issues with granting relief.
Nicole? Hold on, there you are. Okay.
My only concern is that there let's say all of the June stays happened before she got the notice of violation. There was at least one stay after the notice of violation was received because she called them on June 23rd. So
Yeah.
she knew at that point. So that's my only concern. I don't think it warrants no relief, but I think it's worth taking into account.
It's a very good point.
Yep.
Okay? What kind of relief would people be comfortable with?
I'm not speaking on this one.
Well, I think considering that we just considered a case where there were repeat violations
Yeah.
over a very long period of time, I think we can, and we were in my estimation quite generous on that one. So I think that I think certainly we're talking about a year wait. I think something in the 3 to 6 month range sounds reasonable to me.
I did want to revisit, and I think Nicole can speak to it better than that, or Sean can, because he was involved in the negotiations, but there was discussion recently at the Metro Council level about the intention of the waiting period, that those who've let their, I would have thought that those who've let their permits pass without being renewed would be, bigger scofflaws than those who never got a permit in the first place. And I don't think that was the wisdom of the council, right? That those who never get a permit at all and operate is actually considered a little bit more damning to our public policy goals, yeah?
Well, you're not getting the life safety inspections from fire if you never get a permit issued, and that's a pretty serious issue, but I don't know that it speaks to, like, the intent, because that's the other, we're assuming that some people genuinely don't know, and that's why they're not getting permits. It's not just because they think they can get away with it.
Right, when there's not evidence in the record that there was an attempt to circumvent or
Yeah.
repeated attempts to circumvent, then I'm less inclined to stick to anything.
Oh, you don't have your mic anymore.
We were having problems with the broadcast because I opened all the mics. So, yeah, live and learn. Sorry about that. Okay, what number are you?
I'm an 11.
Okay, open yourself back up again. Sorry about that. Yeah, I couldn't remember what the justification was, and it makes perfect sense because the inspections are crucial and the ensuring the safety of those visiting the city should be a top priority. So there was a mention of 3 to 6 months. I think when we're talking about 12 months as the starting point, I'd be more comfortable on the 6 side.
Okay.
But it doesn't have to be 6 months from today. I'd be open to discussion on that.
I'm comfortable with 6 months from June 23rd, which is the day the notice of violation issued.
I'm not comfortable with that
Okay.
because of the fact that there was a stay after
Okay.
the notice of violation was received. So typically, I think what we do in those cases is like six or X number of months from basically the month after the date of last stay. So it'd be like from August 1st.
Okay.
Because we don't know exactly when the
So
stay
month
happened in
of last
July.
day, the last day happened in August, right?
I saw July,
Okay.
but also this was printed out in July. So I think August 1st is generous as a starting
Okay.
point.
Okay. Do you want to make a motion to that, effect, or do you want to continue to discuss?
Well, then, if we're gonna do that, I think I would be comfortable with 4 months from August 1st.
Can we split the difference and say 5?
Sure.
I'd be more
Because
comfortable
I'm
with that.
6.
Sure.
And if
I
you're
was at
4,
6, but
okay.
Okay.
to be
Okay.
expedient, let's say 5.
Let's
Who would
say
like to make a motion to that effect? Who has an open mic?
Who's in a motion making?
Who's in a
mood
motion making
today?
mood?
I haven't made one yet, so
Go
let me
for
go
it.
for
Make you
it.
a motion.
I move that we find that the zoning administrator did not err in denying the permit application, but given the appellant's lack of knowledge and attempts to come into compliance with the code requirements, we would allow the appellant to reapply for a permit 5 months from August 1st of this year.
Second. Can I see a show of hands on that motion? And it passes. Excellent. Okay, thank you so much. So you heard that you're going to work with staff to work that out. And again, as staff mentioned, the requirements in that zone, you're going to have to satisfy those requirements too when you go to reapply 5 months from August 1st. All right, thank you very much. Have a good day. We appreciate your time, ma'am. Very quickly, we do have a quick little housekeeping matter before everybody runs away. If you guys could stick. Okay. There is a change to our rules of procedure that we need to discuss. Who wants to take this on? Ann? Lucky number 13?
Yes. So this is a rule change that we're suggesting to bring the meetings sort of into compliance with state law on those kind of rare occasions when you might have like a case deferred or tied up on votes, in which case the public hearing is usually closed. But under state law, there has to be an opportunity for people to be able to comment on any item on the agenda. So you'd have a case still on the agenda, but maybe a public hearing is closed. So we want to make sure that there's built into your public comment period a provision in case people do want to speak on something that there's not public hearing time available, but they do want to make a comment.
Okay. Yeah, of course. Go.
I thought state law said that, and maybe this just applies to the legislative body, but I thought that there was an additional change that said that you have to allow public comment on anything germane or not germane to an item on the agenda, so long as it is germane to the purview of the body.
Hold on. Go ahead.
So the state law says that individuals have to have the ability to comment on things germane to the agenda. So I don't know that it's broad enough that they can come and speak about anything that's under the board's jurisdiction. But so like this rule change is a good example too, where somebody might have an opinion on a rule change, but there's not a public hearing on that item. There's still an ability under state law for individuals to comment on anything that's germane to the agenda.
Okay.
I move that we approve the proposed amendment to our rules of procedure.
Great. Can I see a show of hands? Terrific. We will make that change. And I think that is all the business we have for today. That concludes the regularly scheduled short-term rental appeals board meeting. Thank you all for your time. Oh, and thanks to Sean Parker for years of service as he continues to serve our community in myriad of ways. It's been a pleasure, an absolute pleasure. Please. Oh, wait. Now you can.
Thank you. Yeah, it's been a real pleasure serving on this board since its inception, and I really want to highlight and thank staff for all the support of this board and just the whole process of managing a very complex regulatory framework, and for the way that y'all treat customers and potential customers so well when they come to ask difficult questions about complicated matters, and the way that you support these meetings. So really, really appreciate y'all across these years. Thank you.
And with,
Quickly,
yes. Yes.
Sorry.
Mister, I have a hard stop. Go
I
ahead.
wanted to commend Councilmember Parker for being an excellent historian for the group. I feel
Yes.
like we wouldn't know nearly as much as we did know about the legislative histories of
Yep.
some of these code provisions. Had you not been present and had you not been sort of an additional voice in the room, that allowed us to make much better decisions. I think we did as well as we did in these terms because of you. So thank you for that.
That means a lot. Thank you.
Completely agree. Anyone else?
Sure, I'll go. Yeah,
turn into a roast.
I just think that this is the perfect, I know at the council, there have been some ongoing debates about having council members on boards and commissions. And so I think that this is a great example of how, even though Councilman Parker was no longer allowed to vote, his input was so valuable because I watch all the council meetings, or I used to at least, but most people don't have that sort of like issue with their brains. But just having a council member here, and I'm excited that we will continue to have a council member on our board, is very helpful to understand what is happening at the council level, what has happened at the council level. And so, I vote in favor of council members being on boards and commissions. Even if they can't vote, they're very, very helpful.
Definitely.
All right. Well, thank you, everybody, for your input and for your service. And that concludes today's short-term rental appeals board hearing. Thank you so much.
Thank you, Chair.
Stick around for the after party.
This This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.